All right, good morning, everyone. So welcome to our first training of the morning. My name is Diana Rashid, and I'm a managing attorney with the Adult Detention Program at NIJC, and I'm here with Hina.
Hi, I'm Hina Mansouri. I oversee the Immigration Division at the Cook County Public Defender's Office.
And so in our day-to-day work representing detained individuals before the detained Chicago Immigration Court, we come across a lot of Crim-Imm issues. And so we've sort of developed a specialty and expertise when it comes to addressing Crim-Imm issues. And I'm sure that you've seen other trainings that we've done for the Illinois Access to Justice Network. We decided to take a slightly different approach with this particular training, so that we could think about Crim-Imm issues in a different way, rather than starting from like the categorical approach, which we will talk about very briefly, but we have a lot of more resources on the categorical approach, which I invite you to seek out. And when we have a training on that, we could spend a whole, 2 hours just talking about the categorical approach. But for this purpose, we really want to make it accessible even for newer beginner attorneys in the removal defense context to really start thinking about Crim-Imm issues from the very beginning and at every stage of the process. And so we're going to talk about Crim-Imm issues in the we're going to talk about Crim-Imm issues starting from the beginning. So when you are intaking your client, when you are gathering criminal history documents, when you're assessing whether they're eligible for any relief, whether they're removable, if there's any risk that they're going to be detained, whether they would be bond eligible if they end up in immigration custody. And so all of these different questions we want to be asking early on and at the various stages of the removal defense process. And we're going to go through some hypos that are going to help us think about that. Okay, so I'm just going to jump right in and start with removability, or the first question, right, that might be on your mind when a client who is perhaps not otherwise removable because of immigration related violations. Say it's an LPR or refugee, an asylee, someone who you are coming across in an intake and you're wondering, this client or this potential client has had contacts with the criminal legal system. And what are the consequences? Are they even removable? Are they eligible for relief? So we're going to start with removability. And so in order to really get into understanding the criminal grounds of removability, we're going to start by talking about the definition of a conviction under immigration law, because this is different than how a conviction might be defined under state law. And as you will see briefly shortly, we will have a discussion about which criminal grounds of inadmissibility and which criminal grounds of deportability require a conviction. Some of them do not require a conviction, and we know that's a very harsh consequence, right? But some of them do, and so when they do, we need to be familiar with what the definition of a conviction is. So the definition of conviction is in the INA at 101A 48A. And it does require, it's a two-part requirement. It requires two things in order for it to be considered a conviction. You need to have a judged order, punishment, penalty, or restraint on liberty in combination with one of the four things on the right. It needs to be a judge, jury finds guilt. There's a guilty plea. There's a nolo plea, right? Like a no contest plea, or even admits to sufficient facts to warrant a finding of guilt. So what are the implications of this very, very broad definition of a conviction? Well, this means that a lot of the adjudications at the state court level that would not be considered convictions, such as deferred prosecutions, where someone might enter a plea, have to comply with some form of probation or drug testing, supervision, et cetera, and then you have the case dismissed because the person, well, they complied with all of the requirements. Now this case is gone. It's as if there's no conviction for state purposes. And in fact, the judge will tell the person, the defendant, that there will not be a conviction because the case was dismissed, right? But what that means on the immigration side is because there was a guilty plea that was entered and some form of punishment or restraint on liberty, which may be as little as complying with conditions such as drug testing or paying fines and fees to be part of those drug testing or supervision programs, that will be considered a conviction for immigration purposes. And we have a case of the Seventh Circuit, Gill v. Ashcroft, which analyzed one of our Illinois state statutes, the 410 probation, or the 410 probation, to assess that that probation for like first time offenders that involve like drug related issues, that was considered a conviction for immigration purposes because it did require those two things. There's a lot more to be said about what entails in a conviction. Like, you need to have some of the same protections afforded, like a guilty plea or a finding of guilt would have to be beyond a reasonable doubt. And so a lot of like ordinance violations that just required a burden of proof on the prosecution to establish to a lesser degree of like, probability or clear and convincing evidence, that those would not be sufficient to warrant a conviction. But for our purposes today, we just want to make sure, especially for those of you who are newer to these issues, that the definition of conviction under immigration is really, really broad. And you need to analyze the criminal records that you obtain for your document, for your clients, disposition and so forth, very closely to see if there was ever a guilty plea entered. And we're going to have an opportunity in a hypo to like actually look at some dispositions so you can have some practice with that. Okay, so the framework of removability is encompassed under grounds of inadmissibility and grounds of deportability. For our purposes, we're just going to focus on the criminal grounds of inadmissibility and deportability, right? So inadmissibility is found at 212, deportability is found at 237. So who gets covered under what ground of removability? So for individuals who entered without inspection, or those who are considered to be arriving aliens or arriving non-citizens, those are subject to grounds of inadmissibility. And as the picture shows, illustrates, those are the folks who entered without inspection. They're crossing, without being inspected, without being admitted, without quote unquote the proper channels, right? Of like lining up at a port of entry, having their documents inspected and stamped, etc. And it also applies to lawful permanent residents in some cases where they travel abroad and they have been convicted of certain criminal convictions. All right, so now grounds of deportability apply to those who have been admitted at a port of entry or adjusted their status. So those are the folks that are under grounds of deportability under 237. So again, as the picture shows, if you're coming quote unquote through the proper channels, right, lining up at the land bridge or at an airport, O'Hare Airport, any airport, or those who are adjusting their status within the United States through USCIS, that will be considered an admission. And for their purposes, if they're placed in removal proceedings, their cases will be analyzed under grounds of deportability 237. So now I'm just going to go through what the grounds of inadmissibility are, then the grounds of deportability, then we're going to do a little bit compare and contrast. And I'm going to go through this very quickly right now because we're going to be able to do a deeper dive after we talk about some of the implications for relief purposes. Okay, so we have under grounds of inadmissibility, you have crimes involving moral turpitude, which in this situation only requires an admission an admission is sufficient. There is a petty offense exception, which we will talk about. But again, this is where a conviction is not required. Controlled substance offenses, also admission is sufficient. So conviction is not required. For drug trafficking and money laundering, the standard is even lower than that. It's a reason to believe. So it's, again, very broad there. 2 or more crimes with aggregate sentences of 5 years or more, and then coming to the US for purposes of prostitution or commercialized spice. We don't see that come up very often. It's not for people generally who have convictions for prostitution. The standard is higher that they came to the United States for the purpose of engaging in prostitution or commercialized spice. So we just don't see it come up very often.
If you the shift just like
oh yeah,
put that way, there you go.
Yeah, maybe. Can folks still see me? Okay.
You could probably even move your left.
Oh, yeah. All right, very good. All right, sorry about that. I'm blocking, my big head is blocking the whole thing. Okay, so criminal grounds of deportability, you can see there's some overlap, right? So you have CIMTs again, aggravated felonies, controlled substance violation, repeats again, firearms offenses, domestic violence and order of protection violations, and offenses for stalking, child abuse, and child neglect. And so here you can see in this slide, it highlights in purple where the overlap is. You have CIMTs, right, show up in both criminal grounds of inadmissibility, criminal grounds of deportability, as well as controlled substance offenses and the human trafficker bar, right? Those show up in both. The differences again is that under 212, you have the aggregate sentences of 5 years or more, right? Which is not in 237. You have the reason to believe, money laundering and drug trafficking, and the prostitution and commercialized vice. And again, for many of those, they don't require conviction because it's reason to believe or sufficient facts to warrant a finding of guilt. Admits to sufficient facts to warrant a finding of guilt. And then under 237, the things that are different here are aggravated felonies, firearms offenses, crimes of domestic violence, protection order violations, and crimes against children, and some other miscellaneous specified crimes like that we're not going to go into right now because they just don't come up very often, but including like terrorism related things. Okay. So this is a very important slide because we just really want to emphasize the point that whatever is in the NTA, you're meeting with the client perhaps for the first time and that you're reviewing their EROP or their paper file with their NTA and the documents that the government has filed. And the client may be telling you like, well, look, like, I do have this crime, but DHS apparently doesn't know about it because they haven't charged it. And you might be confused as like, my client does have some crimes that are not charged in the NTA. Well, DHS does have the burden of establishing removability, and the respondent has the burden for bond and relief, right? We know that. But for any individual who may already be removable for like an immigration related violation, right? Any of our EWI clients or any visa overstays, really the government only needs to lodge that charge of removability, and only one charge needs to be sustained in order for the judge to establish removability. And so their burden is quite low on that front, right? Because they don't have to make out every single charge and have the judge sustain all of the criminal charges that might apply to the particular respondent. Just one is sufficient. And so oftentimes you'll see for EWI clients that none of the criminal stuff is alleged. And even for LPR clients or visa overstays, they don't need to include it. They just need the one thing that will stick. And it causes a lot of problems for us often, right? Because once it comes to relief, then, the client may have an aggravated felony that might make them ineligible for cancellation of removal that, the government didn't even have to prove up or establish because they already had, a crime involving moral turpitude within 5 years, et cetera, right? So just a reminder that like, not everything is going to be in the, on the notice to appear in the charging documents, right? But then also, even for the things that are charged on the NTA, if you have arguments that those are not, controlled substance offenses or aggravated felonies or whatever it might be, even if the client has other stuff that like, geez, okay, well, what's the benefit of arguing that my client is not removable, say for a controlled substance offense, when I already know, right, in the back of like, I have the rap sheets and et cetera, et cetera. I know that they're removable for something else. Like, how should I proceed here? We encourage you to file a motion to terminate, right? You have, it's your job. And if they're not removable as charged, you're not being dishonest by saying they are not removable as charged. The NTA does not prove it up. The documents filed by the government do not establish that. And you would be shocked, as we have been shocked many, many times, when the government who has all the documents, should know everything, right? They have all the background documents, all the rap sheets, et cetera. Don't charge the clients for aggravated felonies that are there, for firearms offenses. I'm looking at you, Dave, that are there, right? Like it's very surprising, but it happens, and then clients get terminated. The cases get terminated. So we encourage you to do that, right? To file the motions to terminate where applicable, where the client is not removable as charged. Okay, so I'm just going to go through bond eligibility, and then I'll turn it over to Hina. So for bond eligibility, so you just have to remember that unfortunately, the INA is very harsh, right? There's this whole statute that outlines who is not eligible for bond. And what does that mean? It means that the immigration judge has no jurisdiction to consider, right? To even any discretion to consider releasing someone on bond when they have certain criminal convictions. And the statute outlines all of these grounds, and it refers back to the criminal grounds of inadmissibility and the criminal grounds of deportability. So this is a statute that you can look at and refer back to, but I'm going to go through the slide that parses this out. Okay, so as you can see, 236C makes someone ineligible for bond, right, subject to mandatory custody if they are inadmissible for anything, pretty much. So any of the criminal grounds of inadmissibility, right? Admissions or convictions for CIMTs, multiple convictions with aggregate sentences of 5 years or more, the reason to believe drug trafficking, the prostitution, the reason to believe money laundering, and then there's several others that just don't come up very often, so we won't spend much time talking about the religious persecution and the terrorism grounds, but just know that they're there. So what does this mean? It means, and controlled substance offenses. I don't know why it's not up there, but controlled substance offenses, very much, right? That's a criminal ground of inadmissibility. That's one of the things that will make even a simple possession of cannabis under 30 grams, right? That will make a person subject to mandatory custody. On the deportability side, removable due to, this one is a little bit less strict. You would be ineligible for bond if you have a felony crime involving moral turpitude when it's within 5 years of admission, if the sentence is for a year or more, like if the actual sentence that was imposed is for a year or more. If you have multiple CIMTs, aggravated felonies, controlled substance offenses, firearms, and then again, pretty much anything terrorism related is going to make you ineligible for bond. But remember, these are just the criminal grounds that make you subject to mandatory custody. There's many other reasons why someone might not be eligible for bond because of their procedural posture. They're in reinstatement, withholding only proceedings, et cetera. So there's other reasons, or arriving aliens, right, who have been paroled, et cetera. But this just applies to the criminal grounds that are relevant for mandatory custody. Again, so just to highlight like what's missing there, especially when it comes to the admitted citizens who we analyze under grounds of deportability. Well, if someone has a CIMT within 5 years, but their sentence of imprisonment is under a year, they're actually not going to be held under mandatory custody. So woohoo. And then 237 A2E, right? Offenses for crimes of domestic violence, stalking, violations of protection orders, crimes against children. If they only trigger these grounds and they're not also multiple CIMTs, right? Because the multiple CIMTs would make someone ineligible for bond, or the aggravated felonies. And just remember that there's a lot of overlap, right, between the grounds that are violations against children, DV, et cetera. Like many of those may also be CIMTs. But if they purely only would trigger the A2E grounds, then the person would still be bond eligible. And once they're bond eligible, it's the discretionary factors that apply. We have a whole training online that you can find through us or CVLS about bond. So we won't spend too much time talking about it, but it's discretionary. You have to demonstrate, it's the respondent's burden, right, to demonstrate that they're not a danger to the community, not a flight risk, and the matter of GERA factors would apply. Okay, Hina's up.
All right, did everyone get that down? Everyone has that memorized, right?
Yeah.
Okay, great. All right, I know it's a lot, but yeah, this is just to introduce you to all of these concepts, and when you have these cases, you will learn all of this stuff. Okay, so I'm going to move on to different forms of relief and how criminal offenses can affect that relief. Okay, so we're going to start with cancellation of removal for LPRs. That is basically the discretionary waiver for lawful permanent residents who become deportable because of criminal convictions. Not all LPRs are eligible for this waiver. If you have not had your LPR status for at least 5 years, you are not eligible. If you do not have 7 years continuous residence, which we'll go into in a bit, you are not eligible. And if you have an aggravated felony, you are not eligible. It's a little bit funny because as you saw that ground, those bond grounds, having a CIMT within 5 years of admission is not a mandatory custody ground, but weirdly, the person with the CIMT within 5 years of admission is not eligible for cancellation. So I don't really know what Congress was thinking. The continuous residence requirement. This is a little bit tricky. How do you count those 7 years? The 7 years starts from a lawful admission. So what that can mean is that somebody who came to the US on a visitor visa, student visa, and then they got married or got a job and they were able to adjust their status within the US, that initial admission on that visa starts that 7-year clock, okay? Whereas somebody who entered without inspection, even if they were able to adjust status in the United States, they don't have a prior lawful admission, so it's that adjustment date that starts the 7 years for them. Does that make sense? Yeah, okay. When does the 7 years stop? So it stops either when the NTA is issued, or when a crime is committed, not convicted, but when a crime is convicted, that triggers the rule. You do have to have a conviction for it to be used against you, but for that convicted crime, you're looking at when that crime was allegedly committed, to stop that 7-year clock, okay? And the crimes that trigger the stopping of the 7-year rule are crimes under 212. So crimes that render non-citizens inadmissible under 212A2, or deportable under 237A2 or 237A4, but they do have to be crimes that are within the 212A2 list. And so that means that if you have a client who is deportable for a crime that is only on the 237 grounds, but does not also fall within a 212 category, their 7-year clock is not cut off by the commission of that crime. So as an example, if you have a client who is an LPR who's deportable for a firearms offense that doesn't fall under any 212 category, like firearm possession, their 7 years is not cut off by that crime, but it would be cut off by issuance of the NTA. So that's what you need to look at there. Conversely, if you have a client who is an LPR, and as we've gone over, they are subject to 237 grounds. Previously, immigration lawyers had made arguments that their time should not be cut off by a 212 offense that is in the admissibility grounds, but not in the 237 deportability grounds. So for example, that possession of cannabis under 30 grams, if you have an LPR who has that offense, it's not making them deportable, right? But if they do have another offense in the future that does make them deportable, maybe a second cannabis offense, maybe something else under the 237 grounds, unfortunately, their 7 years cuts off with the commission of that initial cannabis offense, even if it never made them deportable at that time. And that was a decision that the Supreme Court made in Barton v. Barr in 2020. One victory that was had here in the Seventh Circuit, thanks to Chuck Roth, right, from NAJC, is that that 7-year clock does not stop due to pre-IRA offenses. So IRA was, the Comprehensive Immigration Law from 1996 that implemented cancellation of removal, replacing a more generous previous waiver, the 212C waiver, and creating this stop time rule. So the Seventh Circuit held that because people may have pleaded to offenses or been convicted of offenses prior to that, upon reliance of their clock not stopping, that if you do have a pre-IRA offense, it does not stop your 7-year clock. So basically those pre-whatever date in 1996 offenses. Okay. I'm going to move on to cancellation of removal for non-permanent residents. There are 3 types of non-LPR cancellation within the statute. The most common one is, the 10-year cancellation, which is, where we are, showing that the person has been in the U.S. for a period of at least 10 years before issuance of a proper NTA, and showing that they have qualifying relatives, a spouse, parent, or child who is a U.S. citizen or permanent resident who would suffer exceptional and extremely unusual hardship if the applicant were deported. That is, the most common type of cancellation that we see. But we also have VAWA cancellation, also known as special rule cancellation. That is for individuals who qualify for VAWA protections by virtue of having been the victim of domestic violence by a U.S. citizen or LPR spouse or child, or have being the parent of a child who was subjected to that abuse by their U.S. citizen or LPR parent. That requires 3 years, and as we'll see, that also requires 3 years of good moral character, whereas the 10-year cancellation requires 10 years of good moral character. Finally, there's NACARA, which is form of a pretty old form of relief. We don't see many people eligible for it. In my, how many years of practice? 16, I don't know, whatever, how many years of practice, I've never done a NACARA cancellation case. They were definitely more common before, like in the 90s and maybe early 2000s. Criminal bars to non-LPR cancellation. So there are 2 things that you're looking at. First, you're looking at whether the person can meet the good moral character requirement for the requisite time period. Here on the slide, it says 10 years. That's when we are talking about 10-year cancellation. When it's VAWA cancellation, that's a 3-year period. So a little bit better for clients. But you also have to show that you have not been convicted of an offense under 212A2, 237A2, or 237A3, which are national security grounds. So basically all of those grounds that Diana went over before under both 212 and 237, regardless of your procedural posture, regardless of whether you have been admitted or not admitted, you cannot have any offense that falls under those grounds and remain eligible for cancellation. And there is no time period for that. Okay, so for this 212, 237 ground requirement, it can be at any time. It can have been, could have been 20 years ago. And if you still are rendered inadmissible or deportable under one of those grounds, you are not eligible for non-LPR cancellation. Okay, I was getting a little bit ahead of myself. The 3 years is here on this slide for the good moral character. One thing to note is that there is a waiver for the good moral character requirement for VAWA cancellation if you can show that the offense is connected to the abuse. However, there is no waiver for the not having a 212A2 or 237A2 offense, even if that offense was connected to the abuse, unfortunately. So what is good moral character? So it's within the definition section of the INA at 101F. And you cannot demonstrate good moral character if you have a controlled substance offense, unless it's possession of marijuana under 30 grams, or a CIMT, unless you meet the petty offense exception, or if you have any of these other grounds here, habitual drunkard, prostitution, smuggling, gambling, an aggravated felony if it was after November 29th, 1990, or 180 days cumulatively in jail for any conviction. Okay, so what that means is that if you have a client that spent 12 days in jail, they got 12 days time served for a DUI, and then they got 169 days time served for a misdemeanor retail theft. And they served all that time, and they spent 181 days in jail. They would not be able to meet good moral character, even if they did not, trigger inadmissibility because that's a petty offense CIMT. Yeah, they would be knocked out because of that. And sometimes this requires not just looking at the criminal records, but also like having to dig a little bit deeper to find out how much time your client actually served, because what a client is sentenced to is often not what they actually served. For example, here in Illinois, much of the time you serve half of what you were sentenced to, but for certain crimes it can be 85% or something else. In 2019, a new rule came into place through the matter of Castillo-Perez decision. So that was a decision that Attorney General Barr, I think, certified to himself, basically to create this new rule that if you have 2 or more DUIs within the good moral character period, you cannot, you presumptively cannot establish good moral character. Yeah, was there a question back there?
That includes what then to the reckless.
No. Yeah.
Can you repeat the question?
Yeah, so the question was, does that include DUIs that have been amended to reckless? No, it has to be a DUI. And yes, as an attorney in the public defender's office, amending to reckless is one of our primary recommendations. Yeah, another question?
For the cumulative days in jail, is that for sentence or for what was actually served?
Oh, it was actually served for this, yeah. Yeah, for the 180 days there, yeah. So yeah, on the matter of Castillo-Perez, the AG went so far as to say that even if you demonstrate rehabilitation, that does not rebut the presumption of good moral character. So basically, you maybe have to show that you are going to win like a Person of the Year award for doing something in order to rebut this presumption. And yeah, there was advocacy after Biden came into the office to get this case vacated, but unfortunately, it is still good law. Okay. So again, going into the 212A2 and 237A2 offenses, it's the same ones that Diana went over. And as I mentioned before, these offenses can be at any time, and regardless of whether the person actually could be charged under 212 or 237. So yeah, there was case law on that as well. So you may have a client who is iwi, they're applying for cancellation, but they had a misdemeanor domestic battery offense that is a crime of domestic violence. Crime of domestic violence is only under the 237 grounds, not the 212 grounds. That client could not be charged as being deportable under the 237A2E because they're iwi and they can only be charged under 212. But the board held that regardless of that, just having that offense that is listed under the 237 grounds does make them ineligible for non-LPR cancellation. Okay. Any questions on cancellation before we move on? Okay.
We will have a pop quiz on cancellation.
Yes. Yeah, know your 7 years. Criminal bars to asylum. Okay. So I don't know, it gets a little bit screwy here because there's one term that is defined in different ways for different things, particularly serious crime. For asylum, if you have been convicted of a particularly serious crime, if there are serious reasons to believe that you have committed a serious non-political crime outside the US, if you are believed to be subject to a terrorism or persecutor bar, that does not require a conviction, you will not be eligible for asylum. For asylum purposes, particularly serious crime means any aggravated felony, okay? So it doesn't necessarily have to be an offense that is particularly serious. For example, Illinois doesn't do suspended sentences, but next door Indiana does. And they also have misdemeanor punishments that go up to 365 days, which is a year. So you could have somebody who's convicted of a misdemeanor theft in Indiana and given a 1-year suspended sentence. That is an aggravated felony and a particularly serious crime, barring them from asylum. In addition, even if you don't trigger any of these disqualifying offenses, discretion is an element of asylum. So any crime that you have will be considered for discretionary purposes. Another important point is even if you do trigger other 212, A2 or 237 A2 grounds, so say you have controlled substance offense or crimes involving moral turpitude, unless those offenses are aggravated felonies or are otherwise considered particularly serious crimes, which we'll get into in a bit, those do not disqualify you from asylum and only count against you on discretion. Criminal bars to withholding of removal. So for individuals who are not eligible for asylum, you're looking at whether they're eligible for withholding of removal. Sometimes that's because of criminal reasons, but also it may be because you have a client who missed a 1-year deadline and can't meet an exception, or because they have a prior removal order that was reinstated. And so they can only seek withholding and cap protections. Those are the individuals who are going to be seeking withholding. But there are some criminal bars to withholding as well. You cannot be convicted of a particularly serious crime. And again, you can't have a serious non-political crime outside of the US. But weirdly, even though this uses the same term, particularly serious crime, it does not have the same definition as particularly serious crime under the asylum statute. For withholding purposes, for something to be a particularly serious crime, it either has to be an aggravated felony or multiple aggravated felonies where the aggregate sentences add up to 5 years or more, or any other offense that, under case law is deemed to be particularly serious. And we'll get into that on the next slide. But to start off, one thing to know about particularly serious crimes for withholding purposes is that the determination is not subject to the categorical approach. Notice we haven't really even said categorical approach yet in this presentation. But all of the grounds that we've been talking about, with just a couple exceptions, are strictly subject to the categorical approach. But here we're talking about particularly serious crimes under withholding, and these are not subject to the categorical approach. And so the adjudicator can look at the underlying facts. There are some presumptions that we'll get into on the next slide, and certain other crimes that are more likely to be found PSCs. So what are the crimes that are more likely to be found PSCs? So offenses involving harm to others, particularly where it's, something involving more serious harm, or, a risk of more serious harm. So, your misdemeanor assault or battery is probably not going to be a particularly serious crime, but potentially an aggravated battery or something more serious, where there was a greater level of harm or more egregious facts, those more likely will be considered particularly serious crimes. Things like robbery, sexual assault, those things will generally be particularly serious crimes. Drug trafficking is presumed to be a particularly serious crime, unless you can rebut that presumption by meeting 6 factors that are outlined in the matter of YL decision. I don't think I've ever been able to rebut that presumption for a client with a drug trafficking conviction, because it is, basically, impossible to establish that you meet all 6 of those factors. And yes, we are still waiting for the day when matter of YL is overturned. It's a decision that is based on basically fear mongering against people selling drugs. It's a racist decision, but it is still law, unfortunately. A single conviction for a non-aggravated felony misdemeanor is not typically a particularly serious crime, but there are circumstances that could warrant a PSC finding. So again, you do need to look at what the underlying facts were of your case, particularly if it's an offense that, involves a threat of harm to another or intentionally causing harm to another. Those offenses, will possibly be deemed PSCs, even in limited situations where it's a misdemeanor. Okay, so going into this a little bit more. There is an initial step where you do have to look at the elements of the offense. So say your client had a good criminal defense attorney and they were able to get the offense amended to, something that on its elements is like pretty innocuous, right? Where there's no intentional harm and it's just like disorderly conduct or a simple battery by causing insulting physical contact or something. You can argue then, okay, there's nothing, suggesting that the elements of this statute encompass something that would be a particularly serious crime. So we don't even get to step 2 where we're looking at the underlying facts. But if you have a statute that could conceivably be a particularly serious crime on its elements, then the adjudicator does get to look at the underlying facts of the offense. And everything can come in. Some of the factors that the adjudicator can look at are the nature of the conviction, the circumstances and underlying facts, the type of sentence imposed. Generally, if you say you have an offense where nobody was hurt or there was something exceptional going on, the client can show that it was related to their mental illness. You may be able to argue that the offense is not a PSC. If your client got probation instead of a jail sentence, you can use all of these things to argue that your offense is not a PSC. Okay. Any questions on particularly serious crimes, bars to asylum, withholding? So before I move on, what do you do if your client does have a particularly serious crime? And so they're not eligible either for asylum or withholding? Your remaining form of relief is deferral of removal under the Convention Against Torture, right? And that, requires showing a substantial likelihood that you'll face torture in your home country by or with the acquiescence of your home government. which can be a difficult case to make, but not impossible in some circumstances. And an individual can be granted cat deferral regardless of their criminal history, regardless of whether they're a persecutor. Really, you can have any type of background and still be eligible for cat deferral.
One real
Yeah.
quick thing, just because it came up in the chat, and so for people in person as well, people ask, what is an AGFEL? Which is just short for aggravated felony. So if we're terrible about acronyms and shortening things in immigration world, but so when we say AGFEL, we're talking about aggravated felony, which they're gonna tell you all about all the different kinds of aggravated felonies in the second half.
Yes, AGFEL, aggravated felony, CIMT, crime involving moral turpitude, PSC, particularly serious crime, right? Okay. 212H waivers. So 212H waivers are the waivers that you seek when you have somebody applying for adjustment of status based on a family petition or through certain other avenues, such as under the Cuban Adjustment Act. So when it says CAA there, that's the Cuban Adjustment Act, which is if you are Cuban and you were admitted into or paroled into the US and you've been here a year or more, you luckily are eligible to adjust your status if you don't have disqualifying crimes. 212H is also available to lawful permanent residents when they are placed in removal proceedings upon a return from a trip abroad. So LPRs whose crimes are discovered when they are coming back into the US, say they go to Mexico or whatever for a couple of weeks and they come back in and they get caught by Border Patrol. The Border Patrol sees their record. That person can potentially apply for this 212H waiver in addition to or aside from LPR cancellation. They may be eligible for 212H and not LPR cancellation, but you also may have a situation where they're eligible for LPR cancellation, but not a 212H. You do have to demonstrate that the denial of your admission would result in extreme hardship to a qualifying relative, which for these purposes is a parent, spouse, or child who is an LPR or a US citizen. Note that this is an extreme hardship standard, not the exceptional and extremely unusual hardship standard that we saw for non-LPR cancellation. So it is a little bit more generous. However, that standard does go up to that exceptional and extremely unusual hardship standard where the crime that you are seeking to waive is deemed violent or dangerous. 212H can waive many types of crimes, but there are some exceptions. 212H cannot waive any controlled substance offense aside from one single possession of marijuana under 30 grams, okay? So say you have a conviction for possession of a small amount of cocaine and you got probation and you did it. Unless you have arguments that that offense is not a deportable controlled substance offense, you cannot waive that through a 212H waiver. If you have two possessions of marijuana under 30 grams, even if it's two possessions of marijuana of 2.5 to 5 grams of marijuana, which adds up to less than 30 grams, much less than 30 grams, you are not eligible for a 212H waiver. So, one common theme you'll see with immigration law is that the war on drugs is alive and well. And oftentimes, if you have drug offenses, you are out of luck. Aggravated felonies cannot be waived under 212H if your client was admitted to the LPR, admitted to the US as an LPR. So if the person consular processed and came to the US as an LPR and then they have an aggravated felony, they are not eligible for a 212H waiver. So that returning LPR who initially came in that way would not be eligible. Or sometimes we see situations where an LPR who's not eligible for cancellation of removal is trying to readjust their status. So they have an immediate relative who can file a new visa petition for them so that they can basically reapply for their green card. So they're losing their initial green card, but getting a new green card in proceedings. That individual will only be eligible for a 212H waiver when they have an aggravated felony. If one, that aggravated felony is not a drug offense, it's not murder or torture, and they were not initially admitted to the US as an LPR. So if you have a client who adjusted status in the US, so like all those clients who adjusted, oops, uh-oh, the echo is back.
Working now? Okay, I think it works now, hopefully.
All right.
Actually, I kind of wonder. Seems to be. Okay, cool, keep going.
Okay. Let's see, where was it? So you have a client who adjusted status in the US, so like all those clients who got LPR status through the amnesty or SAW, or who were eligible to adjust within the US because they were admitted, or refugees, asylees as well. People who are subject to 245I and were able to adjust in the US and did adjust in the US. Those people can actually benefit from this possibility of readjusting, even if they have an aggravated felony. That doesn't mean it's going to be easy, especially if it's a more serious crime, right? But it can be a possibility. Okay, there are a few other waivers that we are not going to go into in detail, but I just want to flag them a little bit here. 209C is a very important waiver, especially if you are working with refugees and asylees. Those individuals, when they are seeking adjustment, they have access to a waiver that is much more generous than the 212H waiver. The 209C waiver can waive everything except like drug trafficking and like terrorism and murder. So you can have an aggravated felony, you can have those other drug offenses that didn't qualify for 212H. And seek a 209C waiver. Sometimes that works out in the favor of refugees who maybe came 20 years ago and for whatever reason they never adjusted their status, and then they racked up a criminal record that maybe includes aggravated felonies. They could still seek a 209C waiver, but that is also subject to that heightened standard for violent and dangerous crime that applied for 212H, where they would need to show exceptional, extremely unusual hardship. Though I think by the way that is worded, for them, it could actually be hardship to themselves as well, and not just to their qualifying relatives. 212C is a waiver that existed before LPR cancellation. It is still available to individuals who only are deportable for offenses before IRA. It is more generous than LPR cancellation in that it can waive aggravated felonies so long as the person served less than 5 years. And then finally, the 212D3 waiver. This is when we are seeking a waiver in conjunction with a U visa or a T visa application in front of the immigration judge. When you file that waiver with USCIS, you're filing your I-192, but the Seventh Circuit has held that you can also file that before the immigration judge, and that is something you may want to do for clients where you don't have high hopes that the Vermont Service Center is going to grant their waiver because of their criminal record, and that waiver can technically waive everything. Okay. And finally, voluntary departure. So if your client doesn't have a way to remain in the US, you're trying to at least soften the blow by getting them voluntary departure. Maybe they'll be eligible to consular process in the future. For pre-hearing voluntary departure, so before you move forward with seeking any relief, the only thing that bars voluntary departure is an aggravated felony. So if you have any other type of conviction, if you're subject to other grounds of inadmissibility or deportability, you can still request voluntary departure. Again, it's discretionary, so the judge will still consider your record in determining whether to grant it. Post-hearing voluntary departure, again, any aggravated felony will bar you. But additionally, if you have crimes that prevent you from establishing good moral character within the last 5 years. Again, those offenses we went over before when we were talking about cancellation, but within this 5-year period, that also will bar you from post-hearing voluntary departure. And that takes us to our first hypo. Yeah, first part up here. So this one is not on the handout. I think this one you're just reading up here. So we've got a refugee from Serbia who came in 2002 when he was 13. He became an LPR in 2005. In 2008, he committed a theft of an iPhone. He pleaded guilty and was convicted of a felony retail theft. And he got 1 year probation. So that's offense number 1, felony retail theft in 2008. Okay, and then in 2023, he's convicted again of violating a no contact order, and he gets 2 years of probation. After that, ICE detains him and puts him in proceedings. Okay. We have a number of questions, and this is, feel free to provide your answer out loud here or in the chat. Hopefully Elizabeth can monitor the chat.
We give folks 2 minutes to look at it.
Yeah, so folks want to think about it. There are not just all the questions, yeah. Okay. So yeah, starting from the top, folks want to think about it for a couple of minutes.
I want to add a couple of things here, just so that you know, and it's not too many things to think about at once. For the purposes of this hypo, let's assume that the felony retail theft is a crime involving moral turpitude. And let's assume that the violation of a no contact order is also a deportable offense for violating no contact orders. We'll go into more detail about those things after this hypo. But just to make it easier for you so that you're only thinking about the relief requirements, the retail theft is a CIMT, and the no contact order is a violation of no contact.
Okay. Does anyone want to take a stab at the first question? Is he removable? And if so, on what grounds?
We can take a
Anyone?
poll. Raise your hand if you think he's removable. Okay, pretty much everybody has their hand up.
Okay, now raise your hand if you think he's removable because of the retail theft. Few people?
A couple of
Okay. And raise your hand if you think he's removable because of the no contact order violation. Okay. And who thinks it's both? Okay. So let's work our way through this. Okay, so Chris entered in 2002. He committed the theft in 2008. He became an LPR in 2005. do folks recall when somebody who has been admitted can be deportable for CIMTs? There's two situations. Anyone? Yeah, Sarah?
One CIMT within the first 5 years or 2 at any time?
Exactly. So does he have one CIMT within those first 5 years? Where does that 5-year start? 2002? Yeah. And when's his crime? When does it end? For him, like where do you count that 5 years to?
2007.
Yeah. So he had that theft in 2008, right? So that is outside of 5 years of his admission. So remember, it's his admission date by virtue of which he is in the US lawfully. So it's that date that he came in 2002 that counts, rather than the date he adjusted in 2005. Also, one thing you'll see for refugees, this is not relevant, but their LPR date actually backdates to their refugee entry dates. But even if it didn't, it's that 2002 date that counts. So that retail theft did not make him deportable. Okay. Now how about that protection order? Yeah. Yeah.
I basically told you that. It is, yeah.
Right, because it's a 237(a)(2) offense. There's no time limitation. There's no requirement that it have any certain sentence or that there be more than one or anything like that. So just having that one violation does trigger deportability. All right.
And I'll say one other thing is that violation of a no contact order could also be a crime involving moral turpitude, and then he'd be removable for 2 crimes involving moral turpitude. You have to look at the statute. We're going to talk about that, but just another possible ground.
Yeah. Okay. So next question, is he eligible for relief, and what relief if so?
What about cancellation? So raise your hand if you think he's eligible for cancellation. 42A. So the title of this typo is called stop time rule. So we should be thinking about stop time rule.
Okay, folks, do you guys remember like what the amount of years is? When does that, and when it starts and when it ends? 7 years, and when did it start for him? Yeah, so 2002, yeah?
Yeah.
And when does it end? I'm hearing
The
different
crime.
things. The
Yeah.
commission of the crime, so that was 2008, right? Does he have the 7 years? He does not have the 7 years, right? Does he has the 5 years, right? He's been an LPR definitely much longer than 5 years. But yeah, he's not eligible for cancellation. So what do you want to, do we go into this at all? What do you want to try to do for him? Is there anything you think there might be any other option? Let's say he's married to a US citizen now.
Well, he is, but it's
Oh,
a
he is.
troubled relationship. But yeah.
Okay, yeah, you're right, he is.
They straighten out their relationship.
He's got an alcohol problem, he's in rehab, he's reconciled with his wife, okay? Common fact pattern. Yeah, his wife could potentially file a new petition for him. He could try to readjust because a 212H waiver would waive that one felony CIMT. All right, maybe we'll end there
Yeah.
because it's otherwise could take forever. All right.
Okay.
Problem.
Okay.
Back to you.
So I know that we've thrown a lot of terms already around CIMTs and aggravated felonies. I'm sure you're all wondering, what do all these terms mean? So again, just to mention this briefly, Hina already alluded to this, the categorical approach, which you if you're gonna practice in the Crim-Imm and removal defense, and you should become familiar with the categorical approach. We have resources, and we can put it in the link in the chat, actually, right? We have a recorded training on the categorical approach that you can watch, and we have recurring trainings about this. For our purposes today, we just want to remind you that the categorical approach does apply to whether many criminal grounds of removability are triggered. When thinking about the categorical approach, we're thinking about what are the analysis is. You're comparing the statute of conviction with the criminal ground of removability, and whether the minimum conduct required for a conviction under the state statute triggers that criminal ground of removability. You're not considering the underlying circumstances and the facts of what your client actually committed, but you're thinking about and asking about the minimum conduct required to secure a conviction. And then there's various steps on divisibility, et cetera, that unfortunately we just don't have time to talk about today. But we can put that information so that folks can look at the training on the categorical approach. It does apply to crimes involving moral turpitude, many aggravated felony grounds, the controlled substances grounds, both for inadmissibility and deportability, and for firearms offenses. And then there's a lot of exceptions to the categorical approach where a circumstance-specific approach applies. And we have more of that information in our training. Okay, so CIMT.
Very quickly, Diana,
Yeah.
I think the version of the slides you have don't have the CLE codes on them, so just
Oh, okay.
first of 2 CLE codes for this session, everybody, and if you could repeat this just to make sure it's getting
Yeah.
picked up for the chat, is pumpkin, as in like it's almost Halloween, pumpkin.
Pumpkin is the first CLE. Please jot it down. Pumpkin. Okay, so moving on to CIMTs. So CIMT is not, there is no statutory definition. It is a term that is very archaic, but it still survives in immigration law, and it is defined by case law. And generally the BIA has said, what a crime involving moral turpitude is, and the courts of appeals have generally deferred to the BIA's definition for these types of crimes. It is conduct which is considered inherently base, vile, or depraved, malamente, accompanied by a corrupt mind. It's very hard to say, right? But generally, there are some categories of crimes that there's sort of consensus, both the BIA, the courts of appeals about, okay, these categories of crimes generally are considered to be CIMTs. And again, the categorical approach does apply to that. So in terms of these 2 buckets of crimes that involve deceit and or stealing are generally considered CIMTs. So fraud, forgery, theft, unless the theft does not require a permanent intent to deprive. And then the second bucket of crimes is crimes involving intentional, knowingly, and sometimes even recklessly causing bodily harm. And examples of that would be domestic batteries involving an intent to cause bodily harm, aggravated assault, battery offenses with extenuating circumstances, such as, committed with a deadly weapon. That would be a type of offense that would be considered a CIMT. There is a petty offense exception for a CIMT under the grounds of inadmissibility. So you can avoid deportation for a CIMT if it is a single misdemeanor CIMT, and the sentence imposed, not served, but the sentence imposed was to 6 months or less jail. So 6 months or less imposed, or the client got probation, right? This is a misdemeanor. Then it's not going to trigger inadmissibility for that one thing. Okay, and then generally speaking, these are just to demonstrate sort of the things that are more likely to make something a CIMT and the things that are less likely to make it a CIMT. If you have a protected relationship or a vulnerable victim required by the statute, right? Because it's the categorical approach that applies, it's more likely to be a CIMT. And then aggravating factors like deadly weapons, if that's required by the statute, or if the level of injury is greater. So if it requires bodily injury or serious bodily injury, or, maiming or risking death, those are the types of language in the statutes that if you read that, okay, more likely to be a CIMT. less likely is if it doesn't require that culpable or corrupt state of mind, right? So the mens rea is reckless, negligent, or like strict liability. You did it, you're guilty sort of thing. If it doesn't require a state of mind, or at least knowing or intentionally, well, it's less likely to be considered a CIMT. So what does that mean? Well, your simple battery offenses, battery assaults are generally not going to be considered CIMTs, and even domestic battery that does not require bodily harm. So it's just like offensive contact that is generally not going to be a CIMT. And some ag assault and ag batteries are also sometimes not CIMTs if the reason they are aggravated is perhaps because of the location where it was committed, like an aggravated battery may be aggravated because it was committed on a public way or on the CTA or on a peace officer. But if there was no injury required, no bodily injury, then it's unlikely to be a CIMT. Okay, so controlled substance offenses. So generally terrible, right? Hina already said war on drugs, alive and well. So any offense that is listed, commission of the offense that's listed under this ESA, right, under the 21 USC 802. Again, that is a reference back to the federal schedule. So you want to check, is the state statute referencing all, and there's no overbreath, like everything that is punished under the state statute is the same as what's punished under the federal statute. That's the comparison you want to make for the categorical approach because it applies here. For purposes of inadmissibility, even a controlled substance offense, even a simple possession of marijuana under 30 grams is going to make someone inadmissible. And there is an exception under grounds of deportability for a single possession of 30 grams or less of cannabis or paraphernalia related to cannabis. And this is one of the situations where for the exception, the circumstance specific approach applies. So the respondent or the applicant would have to demonstrate that they're eligible for the exception because the facts in their own case demonstrate that it was for marijuana and it was under 30 grams. But again, if there is an overbreath argument like in Illinois, Illinois punishes substances that are not covered under the federal statutes like salvia, then certain Illinois controlled substance offenses do not trigger the federal ground of removability for controlled substances, either under inadmissibility or deportability. So a common misconception is just that all felony drug offenses are aggravated felonies. I think it's just commonly like people think, well, because drugs are so bad, we keep emphasizing how they're so bad. But no, simple possession is not an aggravated felony. Even if a person has multiple simple possession offenses, it's not an aggravated felony. Of course, it still triggers a controlled substance offense, but it won't be an aggravated felony just because it was a repeat offender. The Supreme Court decided that issue in 2010 with this Rosendo v. Holder decision. Okay, so firearms offenses. Again, this is a criminal ground of deportability right under 237. And the definition, the statute requires that that it must relate to a firearm or destructive device as defined in the subsection of the US Code, 18 USC 921A, which specifies that it has to be a type of firearm that uses an explosive device, and it also it does not apply to antique firearms, fortunately. So what does that mean? That if your state statute punishes antique firearms or punishes guns that don't require explosives, like in Illinois, air guns are air rifles, air guns that use air as a propellant rather than an explosion to propel the ammunition, then it's not going to meet the firearms definition. And so in this case, Rodriguez Contreras v. Sessions, that we have a good decision from the Seventh Circuit saying that the Illinois definition of a firearm is overbroad because of those air rifles. And so Illinois offenses do not trigger the aggravated felonies for felon in possession of firearms or the firearms related of grounds of deportability.
In the chat, folks are asking about Indiana it includes antique firearms, correct?
Yeah, so Indiana and Kentucky both include antique firearms. And generally we've had good luck, I think, because of the way that the Kentucky statutes are worded to argue that that is overbroad. In Indiana, however, they have different statutes for firearms and for handguns. And the handgun one does not include the antique firearm or something like that. So it's more nuanced, or maybe it's the reverse. It's the opposite of what I just said. So the gun is the one that includes the antique firearm.
No.
Dave is about to correct me. No, I think I said it right then.
Is the match.
The hand one is right. It's the one that is not overbroad. So that's what I meant, that it does not include the exception. So it's not overbroad. It is the match. But yes, definitely reach out if you have questions about Indiana, because I left that a little murky. Okay, so domestic violence and protection order violations. So these are under grounds of 237. For a crime of domestic violence to be considered as such, it must meet the definition of a crime of violence, which we'll talk about briefly. For order of protection violations, it must be violated as to the portion of the order that was for no contact of the person. So if there were other requirements in the protection violation, like not drinking or not carrying firearms, those sorts of things, those would not be related to the no contact portion. And if that portion was violated, then this ground wouldn't be triggered. So in the hypo earlier, I said the violation was for the no contact of the wife. So, it did trigger this ground. Okay, aggravated felonies. That's going to be super, super fast because we're running out of time. Again, this is a term of art. It is, the list is at 101A43. Always go back to the statute. Some of these are defined internally by reference to other subsections of the criminal code, other statutes in the criminal code. They are, again, only under 237, but they impact non-citizens under 212. Because why? Well, you can have a person who entered EWI or a visa overstay who has been convicted of an aggravated felony, and they're going to be subject to an administrative removal order without the opportunity to see an immigration judge and have a hearing if they've been convicted of an aggravated felony. And then just remember that an attempted conspiracy is also treated as the underlying offense and can itself still make the offense an aggravated felony. So some common aggravated felonies, I think it's back to you now.
Some common aggravated felonies. So there are some offenses that are aggravated felonies regardless of the sentence. And there are others that need a 1-year jail sentence or need some other factor like a certain amount of monetary loss to be aggravated felonies. Here are some of the most common ones: rape, murder, sexual abuse of a minor. And an important thing to know is that sexual abuse of a minor is defined very broadly. You don't need to have contact with a minor, but there are some exceptions. So, particularly in the context of offenses that could include statutory rape, where the person is 16 or older. Drug trafficking is always an aggravated felony so long as it includes substances that are on the federal drug schedules. But you may have arguments that some statutes are overbroad because the person could be trafficking a substance that is not on the federal schedules. Certain firearms offenses, the most common ones we see are the firearms trafficking and felon possession of a firearm. Another one is possession of a defaced firearm, like where the person has gotten rid of the serial number on it. And then in terms of the ones with 1-year sentences, one very common one here is crimes of violence with a 1-year jail sentence. Crime of violence is defined within the US Code as an offense that involves the use or threatened use of force against another. And through case law, the Supreme Court has held that it does have to be the intentional use of force. So say you had an aggravated battery, where it's intentionally causing bodily harm to somebody, and you've got that 1-year jail sentence, that would be a crime of violence, aggravated felony. Other common ones, forgery-related offenses, theft and burglary with 1-year sentences, obstruction of justice with a 1-year sentence, and then those offenses involving the monetary loss, when those are fraud or tax evasion offenses, and the loss is 10K or more. For determining that 10K, you can look below the statute of conviction. So that is another circumstance-specific exception to the categorical approach. Important note, I mentioned this before, but it's the sentence that matters for whether a sentence-based ag-fel is an aggravated felony, and that can include suspended sentences. Okay, so you have a 1-year jail sentence, even if you here in Illinois, you serve half of that, that would still be an aggravated felony if it's the right type of crime. You have a suspended sentence where your 1-year sentence is suspended and you just do a year of probation instead, or probated sentence, sometimes it's called. That would still meet that sentencing requirement. Okay. One important note though, is just don't assume that because your crime has a right title, that it meets the aggravated felony definition. As an example, Illinois burglary is not an aggravated felony, even when it has that 1-year sentence. There is a 7th Circuit case on point on that. So you really do have to look at the categorical approach and do a comparison. I already went through this about crimes of violence. One thing to note, if you see in the INA that there's a cross-reference to 18 USC 16, subsection 16 for the crime of violence definition. That crime of violence definition has 2 prongs, A and B. Subsection B was found to be unconstitutionally vague. So that's why we are only looking at that first prong, which is the intentional use or threatened use of force. And that takes us to our hypo, our second hypo. Did the handouts make it through the room?
There's 2 parts.
They maybe did not make it through. That side did not get it.
And for
Okay.
folks joining us virtually, I just
Yeah.
shared the link in the chat for the documents.
We have 30 copies, so.
They're over there.
All right.
Go through the facts, you know.
Yeah, so in interest of time, I'm gonna start talking about this. So this is a client, so this is based on an actual client who names of course have been changed. A client who entered the US on a visitor visa in 2004. He was 8 years old. He was placed in removal proceedings in 2021. He has an Illinois conviction for having a gun. He has a US citizen fiance and daughter who has autism. He was a victim of a violent crime. Yeah, he's been placed in proceedings. So the first question, which I think you should be able to figure out even without documentation, is he removable? Okay, and what's for folks who generally know what's his ground of removability? Non-criminal ground of removability.
So.
Overstay, yeah, being an overstay, right? Is he eligible for bond? So to figure that out, you need to look at whether he has any offenses falling within 236C. So basically any 237A2 offenses, since he's an overstay. Anyone want to volunteer who has the documents? So your documents have his NTA. If you have his NTA, there aren't any criminal charges on that NTA, right? But that doesn't necessarily mean anything, as Diana explained. You have that criminal disposition there, which is many, many pages. But if you get to the end of it, you can see which charges were struck, and what he was actually convicted of.
Should we give folks a couple minutes to review?
Yeah, I know we're short on time. What do you think, Jen?
I think we have.
Yeah,
Yeah.
okay.
So for the folks in the room, the handouts are available online, so if the copies didn't make it over to you, they are available in the Zoom, right, in the chat?
Yeah, I put it in the chat, and also if you just scan the QR code, or the tiny URL link should be at the top of the CLE form as well, I think. I should actually test that before I say that, but I believe so.
Anyone want to like interpret that criminal disposition and tell me what he was convicted of? Yeah,
So he was only convicted of the possession of the firearm. And was sentenced to 2 years probation. Everything else was wrong.
yeah. So she's saying he was only convicted of possession of the firearm and sentenced to 2 years of probation. I actually don't remember. I think it was amended down to the misdemeanor. Okay, yeah. So it was amended down to the misdemeanor, firearm possession. Firearms are a ground of deportability, right? But there are some exceptions. You guys remember what those exceptions were that Diana explained?
Remember the Seventh Circuit case, Rodriguez Contreras in Illinois, for the Illinois firearms offense.
Yeah,
That they wanted unconstitutional, that portion of it. So, or that the immigration held that that portion of the Illinois law did not apply to them, correct? Is that what the- I'm understanding?
Yeah, so the Rodriguez
Yeah.
Contreras case found that the Illinois statute is overbroad because Illinois criminalizes possession of air guns, which do not meet the federal definition of a firearm or explosive device because of the air portion of the gun.
Yeah.
It doesn't require an explosive. So yeah, so the
Right.
Illinois statute is overbroad.
yeah, and just to be clear, that doesn't refer to every single firearms offense under Illinois law, because there are subsections that specifically refer to certain types of firearms. So you do have to look at that, but if you have a statute that just generally refers to firearm, and then you go back and look at the firearm definition within the Illinois statute that includes air rifles, that is overbroad. So yeah, Samuel does have such conviction. And so he is not removable under a firearms ground. There's nothing else, right? No other criminal ground. That's the only conviction we're talking about here. Yeah. And what does that mean for bond eligibility? He's eligible, right? So, whether he's a danger to the community because he had the gun, that's an open question that the immigration judge would consider. But he is eligible for bond. In terms of relief, right? So he's undocumented, he's an overstay. He's been here a long time. He's got US citizen, child, fiance. He actually, he's gonna get married soon, yes. Yeah,
This is an actual client.
you know. Yeah. I'm sorry, did you have something? Yeah.
Yeah, I mean, well, the daughter would be enough though, right? If he doesn't get married, and then the VAWA for the being a victim of when the guy shot into their car.
Right, so in terms of the daughter, what's the form of relief you're talking about? Yeah.
Where it goes to the form, INA 290 AB.
Okay,
for being in the US for over 10 years and having a qualifying relative.
yeah, it's a 42B, the non-LPR cancellation application. Yeah, based on having the daughter who's a US citizen and being here more than 10 years, that would be one form of relief for him. He has not triggered any of the bars to non-LPR cancellation. He didn't serve 180 days or more. He does not trigger 212A2 or 237A2 ground, luckily, right? In terms of being a victim of a crime, it's not VAWA, it's the U visa, right? He could seek a U visa with USCIS. And if he got married, right, he also would be adjustment eligible. If his then wife filed a petition for him. So what challenges might you face in his case?
Discretion.
This discussion, right?
Yeah.
Yeah, I mean, that's the biggest thing, right? But
And hardship.
yeah,
Yeah.
discretion and hardship. But the daughter's autism and his active participation in her therapy is well documented, guys. And he has not reoffended, so, all right.
Okay, we have a couple more slides. just to wrap
All
up.
right.
So,
Yes.
this is back to me. So just to put a plug, to plug our newly launched, project with NIJC. We just started a, Crim-Imm technical assistance, hotline or office hours available to, the Illinois Access to Justice Partner Organizations. It's on Tuesdays from 3 to 4 PM. You need to book that online. So you go to our website and under resources for attorneys, you can click on the Crim-Imm technical assistance and the information. It's just a very short form, just like tell us what type of issue you have questions about, what form of relief your client is seeking, and then we'll get you started. And the purpose of this really is to like build capacity among other organizations to be able to represent clients who've had criminal contacts, contacts with the criminal legal system. Sometimes, folks might think that the non-citizen isn't eligible for anything because, well, they have an Illinois, controlled substance offense, or they have an Illinois firearm offense. And then guess what, because of some of this litigation and good case law from the Seventh Circuit, that might not be an issue for the client, right? You will still need to advise the client on the risks, et cetera, but if this resource will help you get started and will help confirm and provide you some resources and research, and it's really just meant to be an educational resource for you all. So we invite you to participate. Also, if you're an NIJC staff member, we are also an A2J organization, so you can also sign up for these queries instead of sending us personal emails about the questions.
I just want to give the second CLE code real quick.
Yeah, go ahead.
I'm gonna run 5 minutes long just because we got a late start, but for people who do have to leave, I want to make sure we
Yeah,
have
and this is
that
our last slide too.
Yeah.
CLE code. Yeah, but just the second CLE code is SPICE, SPICE. That's SPICE, SPICE. And if you guys could just repeat it to be 100% sure people.
All right, CLE code 2, spice, like, well, cinnamon is a spice. Okay, there we go.
Or pumpkin spice.
Pumpkin spice, yes. All right. Okay, so key takeaways, and just basically recommendations. Get your client's criminal history docs as early as possible so that you understand their criminal record. Particularly if you have the time, I do think it's also helpful to try to get not just the disposition, but if you can get the complaint or indictment, if you can FOIA the police report, that doesn't necessarily mean you are going to submit all of that to the court or CIS. Definitely just don't submit everything that you don't have to, but you want to have it to know what's out there. And yeah, again, like Diana said, look for those categorical approach arguments. And yeah, do your research, make sure that you are just always looking to see where things stand on the Crim-Imm issues. Things are changing, lawyers are litigating. We are finding new ways to poke holes in criminal deportability grounds through the categorical approach. But also state statutes change. So a state statute may become broader and become overbroad, or it could potentially become narrower and no longer be overbroad. So keep that in mind. And then, yeah, reach out to NIJC's tech assistance resource. All right. Any final questions before we end? Anything in the chat that we should address?
There are a couple quick ones. Somebody asked, when you're talking about DUIs for sort of DUIs related to, driving with a suspended license and things like that, how does the Seventh Circuit handle those with regard to, I think they were asking about CIMTs.
Yeah, so there's no case law within the Seventh Circuit on that. But that, largely it's because we do not ever see DHS charging aggravated DUIs based on not having a valid license or having a suspended or revoked license as a CIMT. And there is a good argument that that offense is not a CIMT. While the board has held that similar sounding offenses in other states are CIMTs, those statutes required that the person have knowledge that their license was suspended or revoked, that they not have a license. So that is the distinguishing factor. Illinois Ag DUI does not have that requirement. You simply have to not have a valid license or have a suspended or revoked license and commit the DUI. You can be safe, obviously, if you have that pending charge and you are the criminal defense lawyer or you're working with the criminal defense lawyer, try to get that amended down to a misdemeanor DUI for a number of reasons, but it's okay.
And two more questions, one quick one, one that could be its own, well, both probably could be their own CLEs, but the first one just, do all aggravated felonies require that 1-year sentence?
No, so like as we went over before, there are different types of aggravated felonies. There are some that are aggravated felonies just based on the elements of the offense and falling into certain categories. And then there are other ones that require that 1-year sentence. And to know which is which, like everything else, you got to go back to the statute and read through the statute. It's quite lengthy. INA 101 A43. It has subsections A through U. Yeah, it's a good reading.
And then the last question was, advice for foreign convictions and handling those, which I think is its own CLE. But just
Yeah.
briefly, the serious non-political crime, persecutor bars, terrorism bars, there's a whole other suite of criminal issues you want to be keeping an eye out for there. But the same concepts apply in terms of getting the record, looking at it, and
Looking
Right.
at the statute, what was required.
and making sure that it is an actual conviction, because their records sometimes look different from our records, and DHS may be presenting something as one document. It's like, no, this was like a warrant, or this was dismissed, or.
All right, thanks all.
Thank you so much. Just one more time, just to make sure, because I know the audio has been janky. That second CLE code was SPICE, 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 SPICE. And again, the link to the CLE, if you're also going to be doing the session after lunch, save it and do them both at the same time, because it's one single form for the two of them. But so that is that. I'm trying to think if there are any other housekeeping things. We're gonna be back for our next CLE at 12:30 for the folks who are, am I saying that right? Yeah,
Yeah.
12:30 for the folks online. And for the folks here who are in person, the food should be ready in room 901. If you flag dietary restrictions, those should be set aside for that. And yeah, you can spread out, you can eat in that room, you can come back here, whatever is most comfortable. And also just as a reminder, because I know this was like so much information jam-packed, which is amazing. And thank you guys so much. Please remember, like, even we have to go back and check the statutes on these things or look stuff back up. You don't have to memorize this entire thing. The whole point of this is just to remind you that when your client has a conviction, that doesn't mean like, oh my gosh, it's the end of the world, they're not eligible for anything. There's so many ways you can fight on that. And also when your client has something that looks like it's like, oh, that's super minor, I don't need to worry about it, double check because sometimes it's going to be more of an issue than you thought it was going to be in the case. So, all right. Thanks, everybody. We'll see you back soon.
We'll leave now.
Yep, you can.